I was thinking of putting in an amicus brief, but I've never done an amicus brief, and so I didn't do it because I think it's enough that I can just keep up with this case. An amicus brief is a paper that anyone can file with the court. Amicus means friend, so it means friend of the court. And tomorrow is the big hearing with the 14 petitions approximately, none of which are necessary, because what should be happening now, it doesn't matter what comes in, the judge should be looking at one and only one piece of paper, and that's the paper from Sam Ingham where he sends in a notice of resignation as Britney Spears' court-appointed attorney. Well, he can't do that. You can't just resign from representing a client. You have to ask the court for permission to resign. And when last heard, the court was advising Sam Ingham, Esquire, that he just better be putting in a petition to terminate the conservatorship, if you'll recall. And while she has no right to give legal advice, she said, you know, there are many ways to terminate this conservatorship, one of which might be a petition to terminate the conservatorship. And then he said, oh, but Your Honor, she hasn't instructed me to file a petition to terminate the conservatorship, which is why I haven't done it. She didn't use the magic words. All throughout the whole 13 years of transcripts, she's begging to have the conservatorship terminated, because he is her court-appointed attorney. Now, if he put in a petition to terminate the conservatorship, the whole thing would be over unless one of the other parties, like her mother or her father or anybody else, came in with an objection to terminating the conservatorship. And then we'd have a very interesting confrontation between Britney Spears and her perpetrators. But I don't think they would have the nerve to do that. So, and Britney Spears is the one who had the legal knowledge to mention this in court. She said, as I understand it, Your Honor, I can petition to terminate the conservatorship, and unless somebody objects, it's done. And she said, maybe these people will object because they're crooked, they're crooks and they should go to jail, but we'll deal with it then, more or less. She didn't really just say all that, but she did say that it would, all she had to do was ask the court to terminate the conservatorship, and the court had the right to terminate the conservatorship without any medical evaluations unless somebody objects. And I personally think that they're probably too scared to object. They might, but I don't think they would. Because if they object, they reveal to Britney that they want to keep her hamstringed and enslaved, and they lose her. Then we'd cross that bridge when we came to it. Then we would respond to their objections, reveal their fraud, everything in the transcript would be open. But I don't think that's crossing the bridge before we get to it. The point is, this whole thing could theoretically end tomorrow had Sam Ingham followed the court's suggestion and filed a petition to terminate the conservatorship. Then tomorrow, there being no objections, the judge would have the authority to terminate the conservatorship. However, at present, she doesn't have that authority. So people who are hanging on to the news media thinking, oh, will the judge do the right thing, don't understand that the judge's hands are tied unless the legally required procedures are followed, starting with Sam Ingham, Esquire, has to file a petition to terminate the conservatorship, which is what she suggested on the 23rd of June. Instead, Sam Ingham filed this resignation, which he cannot do. Because it would be abandonment of his client. Can't wait to see the ACLU's amicus brief, because like I said, I wanted so much to do that. but I knew I wouldn't do a good job of it because I don't know the proper procedure, which involves you have to send a copy of your amicus brief to all parties and ask them for permission to file it. And if everything looks like it's in order, the parties will probably agree to allow you to file, because if they don't, then you file a request to the judge with an accompanying copy of your amicus brief, and you ask the judge to allow you to file an amicus brief. And if the judge sees that you're coming before the judge, wasting the judge's time asking for the permission to file a perfectly legitimate amicus brief because the other parties objected without a legitimate reason, the judge is going to be mad at the other parties. But you have to know all of these steps, and I don't know these steps, so I did not file an amicus brief, but the ACLU did. And I thought, oh good, now I can learn from the ACLU brief, the amicus brief, plus if they leave anything out of the vast knowledge that I've acquired studying this case, I can tell them about it, or maybe file my own amicus brief. I can tell the ACLU about it if they want to amend their amicus brief, and they can use my information plus their information. That would be the best thing to do. Or alternatively, I could file my own amicus brief, having learned how to do an amicus brief from the ACLU's example. This big shot federal prosecutor who's coming in on the case seems to think that all he has to do is sashay into court and show his pretty face, and the judge is going to appoint him as the court-appointed attorney for Britney Spears. But she can't do that until there's been a petition to terminate the conservatorship of the person, which to date has only been done by one of Britney's fans who notices that nothing's getting done in this case. So Sam Wantuck, a humble member of the Britney fan crowd of millions of people, has stepped up, filed his own petition for termination of the conservatorship, and his petition is going to be heard on the 4th of November, and he's the only one who is following the judge's suggestion, and he actually anticipated the judge's suggestion by filing this a month and a half or 2 months ago. So at present, everybody's dragging their heels. Everybody's getting paid $1,000 an hour. And so far, no petition to terminate the conservatorship has been put in. So this attorney, this big shot federal prosecutor, is going to come in. And I looked at his resume. That he doesn't have any probate experience. I don't think he understands. He's a big time litigator. Wonderful. I love that, but we don't litigate in the probate court. Really, it's not litigated. I mean, I guess you could say they do. I wouldn't say that they don't. You do call witnesses occasionally and cross-examine them. But this is not, that's what makes probate court sort of different from the other courts. And in that everything is pretty much settled outside of court. You go into the courtroom and there's like 20 people that stand up in front of the judge when the case is called, and there are all these people, just like you see in this case. They're all uncles and interested parties, people that want a piece of the action, and they all come forward when the case is called, and the judge tells them, I'll go settle it outside of court and let me know what you decide. And then they go to an arbitrator, and the arbitrator helps them come up with a solution. And you don't take the court's time. Now, sometimes they do. I'm not saying they never do, but generally, probate court considers itself a court of old-time courtiers, where everybody behaves nicely and instead of vicious litigation. Okay, but sometimes a case needs vicious litigation, and this case does. And after this thing is terminated, there will be vicious litigation, I hope. Because I think that's what Britney wants, and revenge will be extracted from these perpetrators. And that's when this big-time federal litigator will really come in handy. But there's one more problem. If they until this thing is dismissed from the probate court, you cannot move it into the litigation court. You can, according to the words in the law books, but it doesn't work that way, because what happens is if you're stuck in probate, this is one of the ways you get captured in probate court. Not only can't you go to the U.S. District Court with a claim that your constitutional rights were violated in the probate court because of this Rooker-Feldman doctrine. There's this doctrine that used to say, it has been since overturned, but there's this doctrine that used to say you can't come into the federal court as a means of appealing something that happened in the state court. You have to go through the state court and then ultimately to the Supreme Court. Well, anyway, and that was used in the case of the prior judge in this case, whose name was Reva Gertz. She's the one who goes on record and tells Sam Ingham, don't tell your client she has the right to make medical decisions, just don't let her know that. And he says, well, it hasn't come up, so far she doesn't know. That took place in this court, and the New York Times or the New Yorker found that in the transcript. The judge actually advising the conservatee's attorney to deceive the conservatee. Now, why is that important? Because that judge defeated another litigant from trying to get into the U.S. District Court based on this obsolete doctrine I told you about, this Rooker-Feldman doctrine. And I believe that was in 2006, and the doctrine was overturned in the courts in 2004. It hasn't been stricken from the system. Another black letter law has not been established in the law books, but it's known that the doctrine doesn't stand anymore, but yet this judge moved for dismissal of a U.S. District Court case where the litigant tried desperately to get out from under her thumb based on this obsolete doctrine, and the U.S. District Court granted that motion to dismiss. But that's no longer the case. And that's why this case may have to go to the Supreme Court, and that's why I'm hoping that this big shot litigation guy is ready to go to the Supreme Court, because that's where it needs to go. It needs to go to the Supreme Court, and it's now time for the Supreme Court to announce that the Feldman whatchamajiggy doctrine is now obsolete, and you can no longer use it or rely on it. Judges can no longer rely on that doctrine to prevent litigants who are having their rights violated in the probate court from going to the U.S. District Court. That might have to happen. It shouldn't have to, because the doctrine has clearly been overturned. It's right there in the case law. Anyone should now be able to go into the U.S. District Court, and when the judge like Reva Gertz, Honorable Reva Gertz, did do in 2006 and motion for dismissal based on this old obsolete doctrine, the up-to-date attorney should say that doctrine no longer is good law, and therefore I am allowed to come into the U.S. District Court and question the violation of the constitutional rights that are taking place in the probate court. Okay? So, the litigant, according to the law books, is now in a position, is still in a position to go into the Superior Court and ask for a full dress litigation. But guess what? That can't happen either, because the probate court has a right to object. And if the probate court writes an objection, the judge, I think the judge has to make this objection, I'm not sure, but anyway, somebody has to make an objection and say, this case is being heard in the probate court and we don't want to lose control of it, so Mr. Superior Court, please don't let this case be litigated. That can happen if big shot litigator attempts to litigate this case, as he should do, after he terminates the conservatorship of the person. So what has to happen, because the judge's hands are tied, she cannot move forward other than burning up thousands of dollars a day on all these 14 motions. And she doesn't want to do that. But if somebody doesn't file a petition to terminate the conservatorship of the person, she cannot do a thing except burn up the estate. And everybody's mad at the judge, and it's not her fault. So if big shot litigator attorney from the federal prosecutor's office doesn't understand that, and he may not because he appears not to have any probate experience, he's just going to get treated the way all three of her other attorneys were treated, and he will not have standing tomorrow in the hearing, and he's going to be another mad attorney. And everybody's going to blame it on the judge, and it's not her fault. So what's happening tomorrow is that there's 15 petitions by about 4 or 5 different parties, all of whom claim to care about her best interests, none of whom are putting in a petition to terminate the conservator. So as far as I'm concerned, none of them are her friend, because that's the only thing she wants to hear. She wants an end to the conservatorship, and she doesn't want any objections when she figures out a way to put in her petition. But she's not allowed to, because she's been deemed not to have capacity. So what has to happen is some friend has to come forward, as this Stan Wantuck has done. But anyone else can. All of these parties who are filing all of this extremely expensive litigation could be putting in their own petition to terminate the conservatorship. Anyone can. I can. You can. Anybody in the world can file this petition to terminate the conservatorship. But nobody's doing it except Stan Wantuck. So in the meantime, all these other people who claim to give a quack about Britney are filing this very expensive litigation, including this guy, this big shot attorney from the federal prosecutor's office. He could file a petition to terminate the conservatorship. Why isn't he doing it? See, they could do it tomorrow. They could do it orally. All the parties are going to be in court. Generally, you don't hear a petition unless all the parties have been noticed in writing with plenty of time to respond. But if nobody objects, you don't need to respond. All somebody has to do, anybody, any one of these people tomorrow could say, Your Honor, I'd like to make an oral motion to terminate the conservatorship just to see if anybody objects, because all the parties are here. And if the judge says yes, then the guy makes the oral motion. The judge asks if anybody objects, and if nobody objects, the motion is carried. The judge is allowed to grant the motion. The conservatorship of the person would be terminated if nobody objects. Now, if anybody objects, what's going to happen? What if Dad gets up and he says, well, I object, Your Honor. Okay, now, as a matter of form, what would happen then is then the judge would say, okay, I cannot grant the motion, and we're going to have to put this off for a future hearing, so you have time to write your objections, and then we can deal with your objections. But how is the world going to view anybody at this point who objects to this woman being set free? Nobody's going to object. Nobody has the nerve to object. It would be too blatantly criminal. Yeah, the judge in the past appears to have cooperated with this criminal activity. But this judge hasn't. So what protection are these guys going to get from Brenda Penny? They have no way to trust that she's a crooked judge like everybody else, just because she might be honest, and then where would they be? They're not going to object. Yeah, okay, that's the point I'm trying to make. Britney could be set free tomorrow with the keys in her pocket and the cell phone in her hand. Then she's in a position to turn everything over to this big shot attorney, and he can start the very heavy litigation that's going to come forward in the Superior Court as Britney extracts revenge against her perpetrators for the rest of us, for all the world, to set the record straight and make things right. Free Britney.